With the trial set to begin barely 2 months from now, the defense team sought to make known its challenges and why it wasn't prepared for the April dates.
The case is shifting and changing.
The way the prosecution have conducted this case is to have one case as a decoy, where all the defense attention is on another date, based upon another witness, and on the eve of trial, 2 months before the trial, hey presto, like a rabbit out of the hat, they come up with new allegations that simply have not been investigated.
And so it doesn't give me any great pleasure to seek to delay a trial date, but I am advising the court that in these circumstances it is so extreme that I have to.
There have been enormous changes on the body of evidence and witnesses the prosecution is relying on, according to the defense teams. In the case pitted against Muthaura and Kenyatta, the prosecution has apparently dropped a total of 7 witnesses. Never mind, defense spent invaluable time investigating allegations of those witnesses.
And there's a total of 28 new witnesses that have been dumped on the defense at the last possible moment. 68.67% of the prosecution's case. 68.67%. It's a huge amount of the prosecution case is completely new.
It's not the same case that we faced at the confirmation of charges hearing. We're now facing a very different case.
It means that our investigation team is simply not able to penetrate the reliability, the veracity, the credibility of the source. And therefore, we are unable to properly prepare.
The presiding judge, Kuniko Ozaki, appeared to have some consideration for the arguments by the defense regarding the untenability of the April 10th and 11th dates.
Can you suggest approximately how much time you need?
Madam President, I would say on our part that we would request for a period of up to 4 months from the last date of a definite disclosure on the part of the prosecution.
The prosecution, however, wants the April dates maintained.
So in a nutshell, the case hasn't been brought. It hasn't changed at all.
Other matters that came up for discussion at the status conference hearings is the possibility of having the cases heard concurrently in order to expedite the trials. Judge Ozaki explained that the chamber had communicated the request to the ICC President's office and was awaiting a reply. Nonetheless, the judge pointed out that the court was facing logistical constraints, including availability of courtrooms.
Even if 2 chambers are composed, it will not be possible to conduct simultaneous full-day trials in both cases. The most that could be done is to share this courtroom and to sit for 4 hours a day on each case.
In addition, the suspects are also requesting to attend trials via video link. Joshua Sang further asked that if it were possible, the trials be moved closer home to the neighboring Tanzania. Sylvia Chebet, Citizen Live at 9.